I'm Tom Wheeler. I'm a visiting fellow at the Brookings Institution, and I am joined today by two other colleagues of mine. We are also senior fellows up at the Shorenstein Center at the Harvard Kennedy School. Phil Verveer, who is a noted public servant and has spent a career in antitrust and public policy. Most notably, he has the distinction of being the original lead attorney on the AT&T, U.S. versus AT&T case. And Gene Kimmelman, who also has an outstanding career both in Congress and Department of Justice in antitrust, and is one of America's leading public policy, public interest advocates. Together, the three of us have proposed the creation of a new digital platform agency, along with a recasting of the nature of the regulatory model necessary for the digital age. The Brookings website now contains a blog that the three of us have written that also includes links to the paper up at the Kennedy School. We are joined today by two noted commentators, Fiona Scott Morton, a former antitrust division official who is now a professor of economics at Yale, and Leslie Overton, also a former antitrust division official who is now a partner at the Axon law firm. This is an interactive session that we're going to be having today. So please submit your questions. If you're doing it on Twitter, it's #TechOversight or @BrookingsGov. And if you want to email your questions, you can email them to events@brookings.edu. The format today is we're going to begin with Phil and Fiona reflecting on antitrust as a tool for overseeing the digital marketplace. Leslie has a slightly different point of view that she'll express, and then Gene will close out with comments on the real politic, if you will, of being able to pull something like this off. But let me set the stage. We are all familiar with move fast and break things, the motto that Mark Zuckerberg came up, which has kind of become the motto of Silicon Valley. And we have become convinced that what that really means is move fast to create rules regardless of their public interest. And that the tech companies, particularly the platform companies, have assumed a pseudo-governmental role of making the rules for the new digital environment, while at the same time lobbying to keep the representatives of the public from establishing rules themselves. And the question then becomes, okay, how do you conduct oversight in this entirely new digital environment? I was privileged to be the chairman of a regulatory agency during the Obama administration. And my experience was that you lived by old statutes that didn't reflect digital realities, and that you had to operate under old procedures that were built on an industrial era model that weren't relevant to the digital era. So the conclusion that the three of us have put forward in our paper, and that we'll be discussing today, is that there is a need to return to the public interest obligations that were long established in common law: a duty of care and a duty to deal. And to oversee those traditional expectations. We need an agency that has digital DNA, that is not a bolt-on to some other agency, but is an agency that has a staff and commissioners that themselves come out of a digital environment and are charged with interpreting those common law principles inside the new digital reality. So, with that as an overview, let's turn to the panelists and hear their thoughts. So first, let's start off with Phil and Fiona. I mean, you pick up the morning paper, and everybody is talking about antitrust as the way of dealing with the new digital marketplace. Is that, Phil and Fiona, is that really the right kind of solution?
Well, Tom, thank you. A amount of time considering that in connection with the project that has resulted in this paper. And our sort of summary conclusion is this, that antitrust is an important tool with respect to digital platforms. But we don't believe that it is a reliable mechanism to deal with the various competitive issues that the major digital platforms raise. Now, why not? 3 reasons. Monopolization cases take a long time. AT&T, which is an analogous case that I had something to do with, took 7.5 years from complaint to settlement. Microsoft, it's a little bit harder to gauge the timeframes, but it took approximately 6 years from the complaint to a resolution, including 2 trips to the DC circuit. So time is a serious consideration. Secondly, the outcome of any litigation is going to be uncertain, and that's particularly true for antitrust cases, given the narrowing of the antitrust laws at the hands of the courts over the last 40 years or so. And third, working out remedies that will reliably deal with the perceived problems is a very difficult proposition, particularly a difficult proposition for the judiciary to handle. So those are the 3 concerns we have. And with that, I'd like very much to get this is Professor Scott Morton, who has written very extensively on these issues and recently. So Professor Scott Morton.
Thank you very much, Phil. I basically agree with what you say. I don't think anybody wants to wait 7.5 years to get an answer to Google litigation that might be filed this week or next. And antitrust law is designed to be fairly narrow, and the enforcement agencies are not designed to engage in ongoing monitoring of an industry. So it's really not going to give us solutions to a lot of the problems that we have. And I want to, I chaired a group that wrote a report for the Stigler Center at the University of Chicago last year, and we recommended both more vigorous antitrust enforcement, but also a regulator of the kind that you 3 propose. And let me just highlight for the listeners the kinds of activities that one would want, I think, to put inside such a regulator. So first, there's a whole range of consumer protection issues, like what are the defaults concerning data that I, the consumer, control? So another way to say that would be privacy. What are the defaults that I get to control? What are the interfaces and the choices shown to me for me to decide to do something different? Okay, because right now there are 75 pages of legalese and I have to hit I agree in order to get to the service I want. And choices can be controlled and influenced and manipulated by the platform. And third, there's an addictive nature to a lot of this technology. Many of our listeners may have watched The Social Dilemma on Netflix recently, which is a great documentary. And actually, I have a new paper with Dr. Niels Rosenquist and Sam Weinstein about addictive technologies and how to handle them in an antitrust enforcement context. So you've got a whole consumer protection set of stuff. Then you've got baseline conditions that determine what sort of competition we're going to get. So things like data portability. Can I take my data from platform A and bring it to platform B? And is there somebody defining the standard for that so that it's useful to platform B when it gets there? An example of this would be open banking in the UK. Or interoperability, so that multiple services can all provide a service to the consumer and they can connect to each other, like email. I can have Gmail and you can have Hotmail and we can connect to each other. The Internet of Things would be something where connectivity would be really important, or autonomous vehicles. If the cars on the road can't talk to each other, then we've got a big problem in terms of making that work. I have also, just to promote my own work, a paper that's out this morning on the Washington Center for Equitable Growth's website that's about interoperability and network effects. And then third, you want to have salience of characteristics like price and quality to enable consumers to shift their business to better offers. We have Energy Star ratings, we have nutrition labels that help consumers figure out what is in fact good. None of these things exist in the digital context, which is really a problem. And then third, we have competition enforcement. So discrimination, raising rivals' costs of existing rivals or perhaps of nascent rivals, small mergers that are going to be below the HSR threshold or are going to require some specific sectoral expertise to see how it is that they affect competition in the future. That kind of traditional antitrust enforcement that's been eroded by the courts is an open area where we effectively are under enforcing along with this consumer protection and kind of rules of the road area. And then last, you might want to prevent existing market power from hurting the consumers and other sides of the platform too much. So you might have an existing market power problem that creates a lot of bargaining power for the platform, and you might want to protect some other sides of the market. So that's just a quick overview of all the kinds of things that antitrust today is not going to deal with in a timely and effective fashion that you might want to put inside the regulator. And Phil, I hope that was an answer to your question.
We have another couple of moments. If I just spend a quick moment summarizing the interoperability paper that you apparently just published this morning.
Oh, sure. It's basically arguing that if you have a dominant firm that violated the antitrust laws and the market tipped to that dominant firm, and it's protected by the network effects, that is to say, nobody wants to change to a different phone system because nobody else is on the other phone system. We're all on the same phone system. My phone, and I value all the other people who have a phone system, that what you could have as a remedy is to require the dominant firm to interoperate. And then if the dominant firm had once been AT&T, now there'd be Verizon and T-Mobile and Sprint, and they could all compete because their phones could connect to everybody else's phones. And that would be a great way to achieve competition going forward without and sort of erode those entry barriers. Great. So now we're going to turn it over to Gene and Leslie.
Can you hear me now?
You got it.
Okay, I'm sorry. I'm not sure how I got remuted. I was saying that I will start with a disclaimer and just say that I am speaking for myself today, not on behalf of Axon or any particular clients, even though we have clients, including Google, who may have an interest in these topics and in the general direction of antitrust law. But I'll say I appreciate the authors being interested in speaking to what they perceive as challenges with digital platforms, but I have a lot of confidence in the ability of the antitrust laws to handle any perceived challenges that arise. And so, and I have that confidence after having been in practice and in government twice and seen the antitrust laws applied to many different industries, including high-tech industries. And I've also seen the antitrust agencies invest in greater capacity, invest in greater litigation readiness, invest in greater ability to monitor consent decrees. And I think that it is important to recognize the challenges that a regulatory approach could present in terms of an adverse impact on innovation and the like. And so one question that I did have for you, Gene, about the paper is, I wanted to understand what market failure you all have determined that you think forms a partial basis for this type of regulation, given the risks that such regulation could pose.
Well, thanks, Leslie. And I too have massive faith in antitrust and the great skills of the people who are the practitioners in the enforcement agencies. But my experience is that we have often relied upon parallel government oversight with antitrust to achieve competition goals. For example, I'll get to the market failure, but in the case that Phil described of leading up to the consent decree for breaking up AT&T, during that entire time, an expert agency was working on how you would interconnect companies, how you made equipment interoperable in a network that was potentially becoming more competitive. And you had dual track work, all promoting competition principles. So here, I think Fiona nailed what is really wrong in the market. Besides waiting a long time in a very dynamic market to see how litigation unfolds and is resolved, you have problems here of network effects and tendencies to tip because of scale economies. And so with digital platforms, we don't have that thing that's comparable to financial regulators or the Federal Communications Commission. And the idea here is to try to fill in those gaps that either antitrust doesn't touch well at all, or where the process is too slow to get at ways to keep entry barriers down, opportunities to enter, opportunities to challenge a market, even if it looks like there's a dominant player, competition for the market. And Fiona's description of an addictive quality here. Again, this is not a assault on any one company or a claim of necessarily misbehavior. If the nature of the use of the technology brings an addictive nature to it, the idea of consumer choice has to be reflective of that. It's not just like you and I going out to the store and buying one kind of lettuce versus another kind of lettuce, or deciding to go to a different store. There's something else going on here. And so we're seeing attributes of the market that are really not well fashioned for speedy antitrust resolution.
Well, and so recognizing that how long any particular antitrust action will take depends on the facts, depends on the circumstances, but there is due process built into that. And so due process can sometimes take some time, but presumably there would be some due process built into a regulatory agency as well. And so couldn't there be litigation of regulatory decisions that would take time and could lead to negative impacts on pricing, negative impacts on innovation, and harming consumers in the interim?
Absolutely. And we're not saying regulation is a panacea. As you'll see actually in the proposal, we're trying to create incentives for all the stakeholders in the market to come together, develop standards, develop norms, with just a regulatory stick over their head, but sometimes you need the stick to apply. And so, of course, there could be challenges, but I think the major point is a proposed regulation with input would set an objective standard out to the marketplace of what the agency is considering, even if there is litigation around it. So it would set new norms around the market.
Got it. Okay.
So I think we now need to turn it back to Tom to drive the conversation.
Now it's my turn to remember to unmute. Well, let's put Fiona and Leslie in the same screen now and give them a chance to talk. You know, I think we can all stipulate that the digital companies have delivered wondrous new capabilities to us and new economic growth. The challenge is that they have, in the process, been able to make their own set of rules and have their own determination as to what is in the public interest. And so the question that I would ask Fiona to respond to is Leslie's observation about the fact that antitrust is sufficient to get to all of the issues that are involved when these companies make their own rules.
Yeah, that's a key point, Tom. And I we started off in such an exciting fashion. I forgot to make my own disclosures. I do expert witness consulting for both Apple and Amazon, among other companies. But it's like saying we invented the car. The car is great, and let's not bother with stop signs, seat belts, airbags, or speed limits. I mean, obviously, cars would then be super dangerous. They'd be useful, but they'd be super dangerous. And I think society has made good choices by putting seatbelts in cars and stoplights on roads. And as a result, we can all drive around safely and quickly. So that's the kind of image I think we have for regulating a brand new industry, is acknowledging how marvelous it is and wanting to keep all the marvelous bits, but also wanting to take the edge off the danger. And I think, as Gene alluded to, the industry itself gains from taking the edge off the danger, because that makes everybody happier and makes society function better and be more supportive of the industry. And if they all come together and help choose those rules, then the rules will be yet more efficient. So I think this is the kind of mindset we want. And when you think about antitrust in cars, you can't imagine that an antitrust case is going to solve the problem of putting airbags in cars. So there's a lot to do here that is outside the purview of antitrust. And I too spend most of my day worrying about antitrust and love it and think it's a great set of laws and a great toolkit. But we just have to recognize what it's for and what it's good at.
Leslie?
So I'll say, I meant to say earlier, when I'm speaking today, I'm speaking about the proposal for a regulator to do competition regulation. And so I'm not speaking about any privacy or other issues. And just because I'm not a privacy lawyer, I'm an antitrust lawyer. And so, I would imagine there are some cautions about regulation that could extend beyond an antitrust regulator. But I'm speaking specifically that I don't see a need for an antitrust regulator given the robust potential for antitrust enforcement, given the capability of the antitrust agencies, and also given the ability of companies to self-regulate, which is already going on in various aspects. And so, but I'll just make a quick point. I think we look and we say, gosh, or some people say, I don't say, some people say, oh, we've got these companies and they've got they've been successful and they're wondrous, as Tom said, but they've been successful, and is that going to change without some kind of intervention? But I think, there is robust competition in spaces where digital platforms compete. And we have seen changes over time. And I'll just remind everyone, because it's easy to forget now, as the economist Andreas Lerner has identified, the internet is filled with examples of so-called dominant firms or platforms or providers that subsequently were displaced by new firms, such as in social media. People can remember when MySpace seemed like they were very, very, very durable in their position. MySpace to Facebook, social networking, GeoCities to Facebook, WordPress, and search, Yahoo, Lycos, AltaVista to Google. And so these spaces are very competitive, and there are changes over time. And I just
Leslie,
think it's important to remember.
Leslie,
Yeah.
I think you're probably engaging in a little revisionist history there, though. I mean,
How so?
let's go back.
look-
Let's go back and talk about MySpace and a guy by the name of Zuckerberg in a dorm room at Harvard. I mean, yes, MySpace was dominant, and it was owned by Rupert Murdoch, right? So there was some clout behind it.
And it was displaced by
So
somebody in a dorm room.
Can I just say, though-
How did he win? He won in the old-fashioned American, my product is better than
Yes.
your.
Yes.
But if you and I today decide that we're going to create a new platform, social media platform, to take on Facebook, we do not have the assets necessary to do that, because since the MySpace activity, the world has been redefined as the fact that people pay for access, for targeted access. And Zuckerberg has a third of the world on his platform. And you and I could get 100 million subscribers and go, wow, what a great success. And not have the ability to deliver what people pay for, because Facebook has sucked in all of the essential information and then hoards it. And so we have to recognize the reality that exists today, not
and
just
can-
what
can
was
I
the nice
jump
story
in?
that happened a while ago.
I'll let Fiona
Also-
jump in.
that everybody loves to talk about MySpace. MySpace was a decade ago. Okay. So one of the things that is very, I think, in all seriousness, telling about people who tell me that this is a very robust and dynamic industry is that the example they point to is a decade old. Right. And why is that? It's because network effects are very serious entry barriers. They create a real difficulty to an entrant starting up a new, imagine somebody trying to start up an email service that could not connect to everybody else's email. Okay. Why would I be interested in that product? I can't communicate with anybody. So network effects are really a big entry barrier. And that, in my opinion, is why you haven't seen movement in this space in a long time, in addition to the conduct that is well known that I've written about with David Dinelli about Facebook's acquisition of potential competitors and so forth.
Okay, Leslie,
Going back to
response.
one more thing that Leslie said,
Yeah.
she said antitrust was robust. I actually disagree with that quite strongly. I think for the last 25 years, we've seen the courts chip away and away and away, and antitrust raise the burdens for plaintiffs so that there's a lot of conduct today that is not actionable that yet causes consumer welfare harm and harm to competition. And if that's the world we're in, then we either need to change it and have an antitrust statute that clarifies to the courts what we want covered under antitrust law, or pick up the slack in some other way through, for example, a regulatory agency. Sorry, Tom, back to you.
No, so Leslie, quick response if you want one, and then we'll go on to a different topic.
Right. So I'll just say, I hear a lot about the law is in such a difficult place, but I think there have been changes in the law. For example, in the Trinco decision that came out when I was at DOJ the first time, there were real concerns about imposing a duty to deal, and I think sometimes people look at antitrust way back in the day and don't necessarily acknowledge some of the concerns that the courts have had over time that have caused them to land where they are.
Okay, let's move on to another point that Leslie appropriately raised, and that is the impact of regulation. And I think, Leslie, you said something to the effect of the impact that regulation has on innovation.
Yes.
And at the FCC, I used to hear all the time innovation and investment.
Yes.
And so that was one of the things that we tried to wrestle with in this paper. And our conclusion was that the reason that it has this impact is because we are trying to do industrial era style regulation, which is rigid, slow moving, in an era of digital dynamism in which the companies themselves are managed by putting out what they call an MVP, a minimally viable product. And so we proposed a new regulatory structure that would continue to encourage innovation and investment. And Gene, why don't you walk through that concept?
Yeah, so we agree, all of us, that there are definite downsides to regulation. You don't want to automatically turn there, and we've seen pitfalls with it. We've also seen benefits of regulation where it can actually bring people together with standards, interoperability, portability, interconnection. And so how to do that in this environment? We thought the best way to do it was have experts from across the community, the companies involved themselves, those with tremendous tech skills, the public interest community, all drawn together as panels of experts to look at whether standards can be set, whether there are norms that can be developed, whether there are ways of improving the way the market functions for everyone. So if you have network effects, if you have a dominant platform, how can you make it viable for everyone to innovate, to invest, to compete on the merits? We recognize that this won't automatically happen. So the idea is to empower an agency with oversight authority to drive that process itself if the Code Council can't come together with these kinds of norms and standards, but also to take those recommendations and implement them if it can be developed through this process. So the idea is to try to avoid all the traditional utility regulation, price regulation, and focus very much on tools that have worked in the past to actually open markets to entry and better competition across platform environments. That's the framework, and we're open to any suggestions about how to make this work. We wanted to put it out as a first step with opportunities for inputs to really make this function well in a digital environment.
Gene raises a really
Gene?
good. Go ahead, Leslie.
Oh, go ahead. I'm sorry, Tom.
No, I was just going to say, go
ahead.
Leslie, it's you. Go to you.
Okay, so I was just going to say, Gene, so are you talking right now, are you talking about the code of conduct concept that's in the paper or something else? Yeah. So there are a variety of functions that could come from this set of stakeholders, but developing a code of conduct, I mean, we focus on a duty of care. I mean, this is not new as a concept in law. It draws from common law. It's driven most of our regulatory statutes with different standards for different sectors. So with that guidance from Congress to try to develop what is the reasonable duty of care for companies like Amazon with a marketplace and their own in-house products with data gathering process, Google across the entire display advertising market, then with YouTube and search, social networking with Facebook and their variety of acquisitions practices and how they've treated those who could be potential competitors. Apple with all its app store practices and then its own apps and payment system. I mean, these are the kinds of companies I think we want to see subject to broad inputs from the entire marketplace and a regulatory agency that could set fair rules of the road.
And I think one of the things that, Leslie, that we felt strongly about is that industrial era regulation was based on micromanagement, the so-called utility style regulation, where everything got dictated. And that's not appropriate in the kind of rapid paced technological advancement that we're seeing now. But there needs to be a public interest component. So how do we set out to say we are going to identify risks and try to manage to outcomes in cooperation with the industry? And so we look back and we said, hey, building codes have worked, electric codes have worked. We've got power codes as to how the industry works together to figure out who gets power in various emergencies. And how do we bring that kind of a more flexible concept into this environment?
So I appreciate very much that you all are envisioning something that would try not to micromanage business. I mean, I think with regulation, there's still that risk. There's still the risk of with a code of conduct, if it's mandatory, still the risk of false positive errors, of higher prices, and inadvertently chilling innovative activity. But I guess, would you all consider a voluntary code of conduct? And so would you all consider that as something? I mean, I know you all envision working very closely with industry.
Well, Leslie, everything is risk. Fiona, you wanted to say something. Go ahead.
Yeah, I just want to remind the audience about the error cost balance. Yes, there's a chance that regulation leads to higher prices or less innovation. There's also a chance that it preserves democracy or lowers prices or increases innovation. So we need to, as a society, think about both the risks and the actual value of the thing we're getting. And one of the nicely explained elements of setting some kind of standard of the form that Gene and the others are talking about is in the Competition Markets Authority digital report, where they explain that if you have standardization, yes, you don't get competition on the elements you've standardized, but you get lots more competition on everything else because there can be entry. And so let's say you took social networks, you'd have a standardized format for images crossing the social network, so I could receive posts from Facebook or from anybody on my new social network, and my new social network could compete on privacy, could compete on the quality of news, could compete on not having an addictive format and having child controls or something, anything. But the point being that you intensify competition on one dimension, even as you may limit it on another, and therefore saying this is a bad idea is not, we can't say that ex ante. It depends on how much we value those two kinds of innovation.
Okay, we've got hundreds of people out there watching this right now who are sending in questions. Let me reiterate. If you want to email them, it's events@brookings.edu, and if you want to tweet, it's hashtag tech oversight. But let me ask Phil to respond to one of the questions. You've worked at the Justice Department, the FCC, and the State Department, dealing with technology policy issues. And one of our questioners asks, can't the existing federal agencies be reformed to accomplish this enhanced regulatory role?
I think the answer is it's certainly possible. The reason to prefer a new agency, I think, is that every institution has its own culture, and these cultures have developed over time. They can be pretty deeply entrenched. That certainly was true at the Antitrust Division when I worked there some time ago, and it was certainly true at the State Department when I worked there recently. And the entrenched culture issue turns out to be potentially a real obstacle if you're trying to accomplish a somewhat different approach to regulation. Likewise, the statutes that one would attempt to amend have been encrusted with all sorts of determinations that tend to be limiting. We have had, as we've adverted to briefly, 40 or more now of really quite conservative judicial approaches to business regulation. And so the encrusted nature, if you will, of the legal structures that these agencies deal with also can be an inhibition if you're attempting to something that's a new approach.
So let's go to how we would possibly get there. And another one of the questions, Gene, is how realistic is it to expect the congressional committees with jurisdiction over the FTC and FCC, the agencies themselves, and the companies that would be subject to a new regulator to get behind the creation of the proposed new agency?
Well, nothing is easy, but we structured the proposal this way for precisely that dilemma. if you picked a winner up front, you would have losers and they would be fighting with each other, whether it's congressional jurisdiction or the agencies themselves. We decided what was important was to start with what is the actual gap in public policy engagement that needs to be addressed, that antitrust, we believe, doesn't do adequately or quickly enough. What are the tools and skills that are necessary to do that well? And that's the debate we want to take to Congress. If they think in their wisdom that there is an agency that can be built out to do that, that would be one way of approaching it. But we thought rather than picking winners and losers, the idea was really to figure out first, what is it you're trying to accomplish? Do those skills exist anywhere? We're skeptical of that, as Phil described, the culture and the history. And frankly, the past practices, we have not done, whether you liked one particular case or not, whether you thought one particular merger should have been challenged, whether you think the FTC didn't investigate well enough on one matter versus another, we have not seen robust action here to get at the kind of problems we're describing. And we're seeing persistent power in social networks and in search, and in now growing digital advertising, maybe online marketplaces and on. So it hasn't been done very well. Someone needs to do it. I think we're envisioning the same committees that have grappled with this in the industrial age should now look at it for the digital marketplace and make that determination. Is it a new agency, or can they totally revamp one that exists? But that can be done within their jurisdiction. The companies, I think, will try to game whatever suits their own purposes. And that won't matter whether it's called the FTC, the FCC, or the new digital platform agency. We'll have to deal with that and the political power that's there. But I think the starting point is get the concepts right and get the tools and skills right, and we can figure out the rest later.
So, Gene, a follow-up to that from a very thoughtful individual and a former government leader who was a champion of the multi-stakeholder process and made the multi-stakeholder process work in many ways, who asks, can't the FTC encourage the development of codes of conduct utilizing all manner of public participation that would become enforceable as undertakings by the companies adopting them?
The FTC could do that, has tried to do that, and has often failed in that endeavor. And I think one of the main failures is the lack of a big stick over it. The FTC has very limited rulemaking authority, hasn't applied it in a meaningful way in modern history, and has a million other things to do at the same time that involve consumer protection across all other markets. So without quadrupling their resources or something, that's a heavy lift, but still needs, I think, a change in the law. So again, if the committees of jurisdiction see these needs and see that there's a way to do that in an existing agency and puts in the power and the resources and the right direction from Congress, that could work. But we think at least starting first with outlining what needs to be done and how it needs to be done is the right place to begin the conversation.
Fiona and Leslie, either one of you want to jump in? We've had a couple of really good questions here. Either you want to jump in on those?
I'll just, I appreciate how well-intentioned everybody is. I just worry about unintended consequences. And I look to history and I look to a couple of examples that FTC Commissioner Christine Wilson noted in a recent article of hers, that are an important lesson on the risks of sector-specific competition regulatory regimes and that they present for consumer welfare and innovation. If we look back at the railroad and airline industries, which were the platform industries of their day, they were subjected to regulation under the Interstate Commerce Commission, the ICC, which has since been abolished, and under the Civil Aeronautics Board, the CAB, also abolished. And there were all sorts of just problematic issues that these agencies were trying to get rates that were reasonable and just and avoid unjust discrimination. But that goal ended up being very, very complex and really getting out of control. And Brookings itself estimated in the 1960s that there was the ICC regulations were costing consumers at least $500 million per year in 1960s dollars. And that ending ICC regulation would create benefits far in excess of costs.
So, Leslie, I am the self-styled amateur historian on this group.
Yes.
But the best argument that we can make is a study in 1960. But the point is this, that I would ask. You talk about unintended consequences. Are there unintended consequences of doing nothing and allowing the platform companies to continue to make the rules? Are we not today living through 20 years, living through the unintended consequences of 20 years of a failure of public interest oversight over these companies?
So I don't think that this is a matter of regulation or doing nothing, because again, we do have antitrust enforcement. The antitrust agency heads are confident in the ability of the agencies to take on digital platforms without.
Of course they are. I'm not seeing much happening. I mean, I don't know what newspaper you read, but I'm not seeing much happening myself.
Well, there are certainly all sorts of public reports of activity going on in this space by the agencies. And I just don't think we are there yet at the point where we've seen
but look,
that.
If you're going to wait for a victorious agency, you're waiting 7.5 years. So now you're doubling Tom Wheeler's, how many decades do we have to live through an industry structure that's not thinking about the public interest? I mean, certainly we can, if you count up only the harms of a regulator, then you're going to get numbers for sure. The point is you also have to count up the benefits.
But Fiona, you acknowledge yourself that these concerns about false positives, about the impact on innovation and the impact on investment, that those are real, that there are other considerations as well, but those are real. So I don't look at it. I mean, I think that if going ahead with regulation raises those particular costs too, and then if there's litigation over those costs, then there's that many years that those costs are on consumers.
So think of it this way. The paper was designed with an understanding that there could be cases filed. So let's assume there is a case filed against Google by the government, DOJ and the states, a case filed against Facebook. Let's say there's movement against Amazon for dominating the growing online marketplace and Apple for its behavior with the app stores. If we have some portion of a 7-year process to go through, even with cases filed, what we're suggesting is it's time for Congress to look at these areas, see if there would even be gaps, regardless of how those cases come out, and think about whether anything needs to be done in less than 7 years to promote innovation, more competition, entry in these markets that would work well with whatever the antitrust resolution is. You're absolutely right, there can be downsides and we need to be mindful of it, but we're saying launch the process to consider these things, unless you're comfortable feeling that like you just file these complaints in court and everyone goes to sleep until it's finally resolved by ultimately the Court of Appeals or the Supreme Court, nothing else needs to be done in the tech sector. We think that's dangerous, and so
okay, there are some other good
proposal to change that.
There's some other good questions. There's some other good questions that I want to make sure we get to in our limited time here. But I also would add that what we have put forward is a policy MVP that we expect will continue to evolve with the kind of discussion that we're having right now. But let me see if I can put a couple of questions together, and Phil, ask you to take first crack at this. One question, I would love to hear any of your thoughts about the concept of safety. And then another person adds on to that, saying the fake news free speech challenge exists, particularly as AI becomes effective at persuading personally targeted individuals. Are these likely issues for such an agency?
think these are easily answered in the context of the proposal we've made, which is that we have prescinded from any of the negative externalities that the platforms throw off, leaving that for others in the future to contend with. Our concerns have been the competition issues, as Fiona had suggested, and I think as well. Our concerns have to do with competition for the market. I'm sorry, competition within the market, not competition for the market, and trying to figure out ways to enhance that. Without a doubt, there are tremendously difficult questions that surround things like the safety of the use of the platforms, hate speech, foreign interference with our electoral process, misinformation, and so forth. Them tied up in Section 230. Not a moment wandering into that particular swamp.
Can I
Fiona?
amend that, Tom? I would say that competition is somewhat related to this. However, if you have, for example, multiple car companies, you can have the Volvo strategy of competing on safety.
Right.
You can have the Disney strategy of wholesome family entertainment. So I do think that having a monopoly provider does not allow the whatever competition markets might deliver on the safety front to be available to consumers, and that's another harm.
So let me dive into this
That's
question. I'm
exactly
sorry,
right.
Phil. I'm sorry, Phil. Go ahead.
Yeah, I was going to say that's exactly right, and we do acknowledge that if you could get a competitive environment, you would get the possibility of variety along many dimensions, some of which would try to contend with some of these other issues. Absolutely correct.
So there is another question that kind of follows on this that says, could the digital agency be used to determine competitive payments by a platform to a collection of atomistic, very small providers, such as news publishers or Facebook, news publishers on Facebook, app developers on Apple, merchants on Amazon, etc. So can this agency get involved in price regulation, if you will? Phil, you want to try that?
Sure. Look, one wants to be perfectly honest about this. If you get into requirements for non-discrimination, if you get into requirements for Tory access, at some point there are going to be disputes about how much, issues about interoperability. Who should pay? How should they pay? What exactly does interoperability mean? A whole series of issues like that. These are very serious questions, and eventually you cannot avoid the notion that issues of price will enter into that. My hope would be that these would be interventions that would be ad hoc and only in aggravated circumstances where the parties themselves can't straighten out how much money should change for what. But it's familiar in ways. It's a familiar issue in terms of disputes, both judicial and regulatory. And if one takes care to say that these are things that arise only in aggravated circumstances, I think we can manage our way through that.
So we've,
go ahead, Gene. I'm sorry.
Well, we've avoided and think it's appropriate to avoid focusing on any form of price regulation tools for this kind of a dynamic market. However, one of our analogies here was the cable industry, which Congress passed a statute separate and apart from antitrust enforcement of cable, where it required certain non-discrimination rules. And it required, without any pricing power, forcing arbitration of disputes. Didn't work as well as it should have worked more quickly. There are things that could be refined there. So there are tools that can drive resolution of the kind of problems that are being described there as discriminatory practices without the agency having to do any kind of direct price interventions.
Yeah, let me pile on that for a second. I think that's a really good point, Gene. The code process that we propose is not a price regulation process. As Phil indicates, eventually you have to get to issues, but presumably we could also address those issues through that new structure. And the second point I would make is there was once a chairman of the FCC who said competition, competition, competition. And the solution to being able to have competitive prices is to have competition that keeps the other guy honest.
Yeah.
So
So
we've
that's
got
what I was going to say.
Fiona.
Set up the rules of the game, and there's entry, as Gene keeps emphasizing. Then price regulation really never arises because there are choices. If people don't like the price, they trade with somebody else. And that's the world we really want to get to. And then, as Phil said, your price issues become quite rare. So I think setting the rules of the game and making entry barriers small so that there's a lot of entry and a lot of choice for consumers obviates a lot of these problems.
So we've got about 3 minutes left here, and let me again pick up a new topic that really relates to a question that's come in, the political realities that we see today. So the question is, the referenced paper suggests that we have a 3-person commission with 2 people from a single political party. In the current climate, wouldn't such a commission become a tool for political meddling and censorship? Phil or Gene, you want to take that on?
Well, I don't think so, because I think it follows the pattern of all of our agencies. And to the extent we have that problem today, in today's world, we will have that problem tomorrow, and every agency will have to deal with that. That's not new. We're going to have political fights about how any one agency is controlled, but we've not wandered into content regulation with these proposals. These are tools for competition, and so there's nothing that should in any way enable censorship out of this kind of an agency.
Phil, you want to add anything to that?
Well, only that if one reads the paper, you see that we've included an aspiration that it be a technocratic institution more than a political one in terms of the selection of both commissioners and staff. Whether that can be accomplished in the world of time and space, only time would tell, but it seems to me that's the right place to begin, that this is a technocratic set of propositions that we're urging.
So just to pile on to that for a second, one of the reasons for having a new agency is to have an agency with specific domain expertise that extends beyond the legal/political background that you represented so-and-so, or that you were on the Hill dealing with this issue, and gets to having an agency that at the commission level has folks who have been involved having to make managerial decisions, and can bring that kind of expertise along with our digital expertise to the process, and then populating the staff of the commission with digital engineers who frankly think different from analog engineers that today populate most commissions. But and so the opportunity, the challenge I think that we have here, and I go back to this MVP comment that I made before, is that this is a work in progress, just like software is an ongoing work in progress, and that we need to bring a new thought process. What we tried to tee up was a new thought process that then we welcome debate and discussion on. And we're now running down to the top of the hour, but I would turn to Fiona and Leslie, who have been most patient while Phil and Gene and I have pontificated over there. Is there anything that you would like to add before we sign off?
Oh, thanks for the invitation. Great discussion.
Yeah, I appreciate the invitation. I appreciate you all hearing my concerns and cautions.
Well, this is great. Thank you, Leslie. Thank you, Fiona. And it's a privilege to be able to associate oneself with guys like Gene Kimmelman and Phil Verveer and the Brookings Institution. And we thank Brookings for sponsoring this. Again, if you go to the Brookings website, you can find a blog that Phil and Gene and I have written on this topic. And included in that blog is a link to the paper up at the Shorenstein Center at the Harvard Kennedy School. So thank you all very much for joining us.
Thanks for watching. Be sure to like and subscribe for more videos from Brookings.